Okay, it's no surprise that IR35 reforms are coming, but many people are confused as to when and where the rules apply. I think in particular, this comes down to talking about company size. A lot has been mentioned about the small company exemption and also the jurisdiction in terms of where and when the off-payroll working rules might apply. So Bernie, do you have any sort of input on that?
I think that the small company exemption has caused a few problems. I think because of the way obviously the client is structured. Well, first of all, there is a lot of confusion as to whether agencies who are small are covered by the exemption, and of course we know they are not. It is only end clients who are small that will be exempt. Any agency of any size is always within scope of the off-payroll rules, in the sense of, their responsibilities to either pass the SDS down the chain or as a fee payer. And regardless of their size, they have to comply with those obligations. But for clients, I think the small company exemption, where it is different depending on the structure of the company. So if it is a company that is subject to the Companies Act, that is relatively simple because it sits in line with the small companies regime. So companies generally understand that. They know if they sit within the small companies regime or not. But for companies that don't sit within the Companies Act definition, so businesses rather than companies, they have a simple turnover test rather than that three-limb test of turnover, balance sheet, and average number of employees. So there's some difficulties there when businesses aren't necessarily sure how their client is structured and therefore which kind of small company definition applies. I think also the complexities around changes over time and actually when the off-payroll rules start or cease applying for them. And particularly for companies who are subject to the Companies Act, they need to exceed the criteria of the small companies regime for 2 consecutive financial years. Then they have to look at when their filing deadline is for their accounts. And then it is the next tax year for which any changes take effect. So it all kind of gets a little bit difficult, a little bit, stressful, if you like, because it's not as soon as you are medium or large, you start applying the rules. It is you are medium or large for 2 consecutive financial years. Then you've got to look at your filing deadline, which of course is 9 months later. And then you look at the next tax year that starts after that date. So although for the purposes of go live, most companies will know where they sit, I can really see once the rules are live and it's, the new normal, I can see real issues around the complications of changes in size over time.
And it's also fair to say there's a requirement for clients to disclose that information, isn't there? So where there potentially is confusion, the fee payer and the worker has a right to request from the end hiring organisation a determination of their size, so that they can just double check as to whether those rules apply. And I believe that's a 45-day timeline, isn't it? Whereby, again, a bit like the client-led disagreement process, there are 45 days in which the end hiring organisation has to respond with their size determination.
Yeah, and one thing that I always recommend to the agencies that I speak to is to get a signed declaration from the client before the start of every tax year to confirm their exemption status. Because if a client is exempt, it is always exempt for that full tax year, regardless of any changes during that tax year. So, so for agencies who really want to sort of belt and braces it, the whole point is, you get a signed declaration from the client before the start of every tax year, and then you can forget about it, until the beginning of the tax year afterwards. That doesn't mean that the client shouldn't be determining its size in that time, but at least the agency knows exactly where it stands. But the other thing that I do say to agencies is, please don't try to determine your client's size for them, because, even if they are relatively simple in terms of where they sit, whether they're small or medium or large, just because you are dealing with an entity, a client who is small in isolation, that client needs to consider its group structure, if it has one, and any joint ventures, and actually indeed any connected companies as well. Many agencies won't know if that client is connected to other companies. They may know the group structure potentially, but connected companies, I think, is something that isn't easily understood or found. You can find it on Companies House if they are subject to Companies House. They're a structure that sits within the Companies House remit. So, it's really difficult, and much more difficult than I think agencies believe. So wherever possible, not supporting your clients with that determination of size is the best thing to do, because if you get it wrong and your client goes with that and it turns out that they were not exempt because they were part of a group or part of a connected company setup, well, there's some serious reputational damage to the agency for advising them incorrectly.
Yeah, couldn't agree more. And now let's look at the geographic side of things. In terms of offshore, again, there's a bit of confusion that gets created about that. But it's fair to say that if the end hiring organisation is wholly overseas and doesn't have a permanent UK presence, again, the rules will not apply. But have you got any thoughts on that?
Well, again, I think the thing is, it's not as clear cut as maybe HMRC guidance would have you believe. So, the client has to be wholly overseas, which means it cannot be UK resident and it cannot have a UK permanent establishment. But of course, there's no statutory definition of what is resident for a company. So that in itself potentially leads to some ambiguity. I mean, if the company is incorporated in the UK, then clearly they are resident. But if they're not incorporated in the UK, then you have to work out where the central management function of the business is. And if that is in the UK, then they are considered UK residents. Permanent establishment is potentially a little bit easier because there are, HMRC guidance does give some, good descriptors of what is considered a UK permanent establishment. But even then, a construction site is considered a permanent establishment, a mine, a quarry, those types of things that potentially businesses wouldn't necessarily consider to be a UK permanent establishment. And also, of course, the UK's jurisdiction, it goes past its landmass. So if you have an oil and gas installation, for example, within 12 nautical miles of the UK, well, that would be considered a UK permanent establishment as well. So there are all those kind of factors to consider around that wholly overseas exemption. A lot of things, a lot of scenarios will be relatively simple, but there will be a lot of other scenarios that actually you really have to get into the nitty-gritty, and I think again that can cause some issues.
Yeah, certainly. And I guess it's worth pointing out before we move on from this topic is of course that in the situations where the end hiring organisation is offshore, or indeed the small company exemption applies, this doesn't mean that IR35 is off the table. It's still there and something that needs to be considered. It's just you're talking about a different set of rules, aren't you? And we're just basically falling back to the rules that we've had since 2000 in terms of the responsibility, falling back to the contractor to be responsible for their own sort of status assessment. So yeah, lots to think about there.
I think that's a really good point, Chris, because you see quite often, we saw it last year, for instance, when the postponement happened in April, and the rhetoric, particularly in social media, was that IR35 has been postponed. And of course, that's simply not the case. IR35 is still the same as it was back in April 2000, And I think there's this misconception here that, you know, if the reforms, if people are not caught by the reforms, they don't have to worry about IR35, and that's simply not the case. What you're really saying is the liability sits with yourself if you've incorrectly determined your IR35 status rather than the fee payer. And that's a really important message to drum home that I don't think people are realising.
Yeah, exactly. Now, when it comes to talking about assessments, a lot of people talk about tools and you know, jumping onto websites and filling in some questionnaires. Notably, CEST. I think there's a lot of debate about CEST and its suitability. I mean, I certainly know from a recent study that I saw that I think it's only about 85% of situations was CEST able to actually generate a response, and meaning that for 15% of the situations they couldn't reach a conclusion. So yeah, Tom, have you got any thoughts about CEST and again, looking at what people are saying about it? Can it be trusted? Should it be used?
I think CEST, and to an extent, you can say other algorithms that look to judge an outcome that is based on the answers that's given are always prone to error. CEST particularly has flaws, and I think there's no secret about that. There's massive flaws in CEST, and certainly I wouldn't be saying to someone, rely on what it gives you, because it's been shown to be incorrect. Even through the courts in case law, it's been shown to give a different answer to what the courts came with. But I think that the point in general is that if you have any system where you answer a series of questions and it gives you an answer, okay, can you rely on that answer? Well, the simple answer is no, if your working practices do not reflect what you've input into it, because it's giving you a determination quite simply based on a real life scenario that isn't there. And this is where I think there's this disconnect between, okay, I have this contract and I have this determination and I'm outside IR35. Well, when HMRC come knocking and say, okay, we accept that you have this determination, now let's look at your working practices, actually that does not reflect either the contract or what you've input into the algorithm to get that outcome, it's not going to be worth the paper it's written on.
Yeah, I agree with you, Tom, completely. And I think, you know, we have evidence of that. You know, HMRC, you know, have been at pains to say that they will stand by the outcome of you know, a CEST tool outcome. But actually, we know that that's just not the case, right? Because, you know, NHS Digital have been fined £4.3 million in unpaid tax and NICs because of the way that they filled in the CEST tool. And, you know, we don't know the exact circumstances, but the whole point is that clients who think that if they use CEST, where if and when HMRC comes calling, they can just show the CEST outcomes and HMRC will say, okay, great, that's fine, thank you very much, we'll leave now. That's just not true. You know, HMRC are still going to delve into the realities of those circumstances and those assignments to determine whether you have used the tool correctly in their view. And if you haven't answered those quite vague multiple choice questions in exactly the same way that HMRC would have done, well, then they will not be standing by that decision. And then you, as the client, are exposed to all of those tax and NICs liabilities because you haven't taken reasonable care as a client. So, you know, I think people perceive there's a protection around CEST that simply doesn't exist. It's just not true.
And I think you have to extend that further, you know, where insurance is offered based on the input that's been put into an algorithm. You know, is that insurance company going to stand by that and defend it? Because quite frankly, I think any insurance company is going to say, well, you gave us incorrect information, therefore you're not insured. I think it's very, very dangerous not to give full consideration to the working practices. That is key for me.
Yeah. I actually, as far as I know, none of the insurance products on the market that specifically deal with IR35 and off payroll liability. I don't think any of those policies that are available on the market cover CEST. I think CEST is excluded as a tool that could be used for which the policy would then indemnify. And that in itself is really good evidence of the fact that CEST is a poor tool, it doesn't align with case law, and it doesn't give an accurate outcome.
Assessments are just a measure of a situation at one point in time. And, this is a continual situation that needs to be monitored and reviewed. Working practices can and will change, quite often. With projects, there could be mission creep, and before you know it, you can find situations where contractors are being asked to do something slightly different. So again, it's something that requires a lot of attention to detail and revisiting the situation to make sure that the working practices again continue to reflect the original status decision that was reached.
And you're right, Chris, and I kind of use the analogy of it's a bit like an MOT. You take your car in for an MOT and it passes that day. Now, if you don't maintain it throughout the year and the police stop you, you can't just wave your MOT certificate and say, look, it's roadworthy. You have to make sure it continues to be roadworthy, otherwise you're liable. And that's the exact scenario with IR35.
Yeah. Okay, let's move on to talk about blankets. There seems to be lots of talk about blankets, and it's a particularly cold day today, so we'll talk about that. There are three sort of situations here. We've got, and again, people get confused about this. We have blanket decisions, we have blanket assessments, and we have sort of blanket banning. And obviously, anyone that follows social media will see that the term blanket gets sort of overused and misinterpreted. In some situations, blanket banning is okay. For instance, if at the end of the day an end client determines that the off-payroll rules are just not for them, and they decide that they don't want to engage in a certain way, then that is clearly their decision. But Bernie, do you just want to sort of talk a bit more about some of the other areas here in terms of, making a blanket determination or decision or blanket assessment, and just there's some slight nuances there where one is okay and one is not okay. So I think it's useful just to explore that.
Yeah, sure. So yeah, as you said, Chris, there's kind of, if you like, three types for want of a better word. The first one is where the client says, we are not going to assess individual contractors. We're just going to decide that everybody is inside IR35. So agencies can continue to supply PSCs to us, but they will always be inside IR35 without doing a proper assessment of the facts and circumstances of each assignment or each group of workers. And under those circumstances, then the client will be liable under the off-payroll rules. So that approach is specifically not allowed under the off-payroll rules. And in fact, HMRC have made it clear that clients who take that approach will not be deemed to have taken reasonable care, because all they've done is say everybody is inside. And even if the tax and NICs has been paid further on down the chain by, for example, the fee payer and the individual worker, the client will be charged the same amount again. So there is a clear deterrent for companies looking to use that approach. The second type is a blanket ban. So by that, we mean there is a policy decision within the client to say, we will not engage PSCs at all, and none of our agencies are allowed to supply us with PSCs. Now, because of that policy approach, there are no liabilities under the off-payroll rules, because, of course, if there are no PSCs in the chain, the off-payroll rules don't apply at all. They simply fall away. And of course, that's difficult then for agencies or indeed, individual workers to overcome that policy position. But there are some real commercial disadvantages. There are no legislative disadvantages, but clients who take that approach, will be boycotted. And I know that the circumstances and the economy at the moment there is a lot of uncertainty, and people are staying in roles that they're in now because of that uncertainty. But we will not be in this position forever. And clients who have taken those policy decisions, they will only attract the most desperate contractors. The good contractors who know their value, know their worth, and they know they're outside, they will leave those assignments and they will go to other clients where roles are deemed outside IR35. And I think the difference between this blanket ban in the public sector that we saw with some government departments versus the private sector is that private sector businesses have competitors. The public sector don't. So you have a situation where you have two companies that do very similar things and therefore need very similar types of contractors. One has done a blanket ban and the other is assessing properly. Well, they, of course, that company that assesses properly are going to have plenty of roles that are outside IR35. Well, they'll be inundated, with CVs and applications for roles in the future, whereas the first company that did a blanket ban will not be in the same position. And so, that commercial reality is going to impact them, as the economy picks up again and, as more contractor roles are opening up. And people don't forget, contractors are a close-knit community. We still see some public authorities being boycotted even now, years later, because of the way they dealt with the off-payroll rules. And private sector clients are going to encounter the same. There's no doubt about it. They are vilified in the press and on social media, etc. People don't forget that. So, they'll have a long way then to overcome. Whereas the clients who assess right now, they are going to be in a much better position. And then the third type of kind of blanket determination, if you like, are role-based assessments. So instead of assessing each individual contractor, what a client may do is say, for example, we have 15 design engineers in our business. And what we're going to do is assess the role of design engineers, and that IR35 assessment will then apply to all 15 of the contractors that are completing that design engineer role. And that can be a way for clients to do that, particularly if they have a lot of contractors. But obviously they must make sure they are accounting for any differences and any subtleties and nuances between that contractor population. If they take their role too wide and don't account for individual differences, then of course they will be considered to not have taken reasonable care.
Yeah, good. So the status determination statement that's produced at the end of the assessment process, again, a lot of confusion comes around that in terms of what to do in situations where the supply chain, notably, agency one or the worker disagrees with the assessment that's being provided. But then also exploring, what happens when it is wrong, and where does that liability sit? This is obviously a very important topic for the parties that are considered to be the fee payer. So yeah, but Bernie, in terms of your thoughts on that, I mean, how do you look at it when it comes to the failure to pass on an SDS? I mean, whose responsibilities are it, are there to pass on that SDS, and what are the liabilities that the client would face or the fee payer would face?
Sure. Well, obviously clients, all liabilities, if you like, start with the client. So if they determine their size incorrectly, they think they're small and therefore exempt and they're not, or if they fail to do a determination with reasonable care, or they fail to pass the SDS down to the next agency in the chain to the client and the individual worker, him or herself, or they fail to implement a status disagreement process and follow the minimum requirements of the legislation, then the client is liable. And those liabilities basically encapsulate the income tax, the employee's NICs, the employer's NICs and the apprenticeship levy payments that would have been payable under the assignment and weren't, as well as interest for previous tax years. And what I would say is, this legislation is not retrospective, of course. It does only apply from the 6th of April 2021 onwards. But just because clients or fee payers don't get a knock on the door in 2021 does not mean that they're home and dry. HMRC can look at those arrangements in 3, 4, up to 6 years' time. So, if they penalise the client or the fee paying agency for what was done 6 years previously, well, then there's interest payable for the duration of which they didn't get it right, and the liabilities are then paid. So, that interest alone is significant. And then, of course, HMRC can impose additional penalties and fines just by virtue of the fact that, the relevant party did not comply with their obligations. So, that's what the liabilities are. They are the circumstances in which clients are liable. And then, of course, fee payers are liable if they fail to act in accordance with the status determination statement of the client, particularly if it's inside IR35. But they also hold this fee payer risk, which is, if the client has given a status determination statement that is outside IR35 and they have taken reasonable care, then the client has fulfilled all of its obligations under the off-payroll rules. The fee payer would then be liable if HMRC at a later point looked into the circumstances of that assignment and said, actually, the client was wrong. For that particular assignment, the determination should have been inside IR35. But the client isn't liable because they took reasonable care. Under those circumstances, the fee payer is liable. And that, of course, is causing a lot of consternation within the staffing community, because they're saying, but we aren't allowed to do our own status determination statements. They won't be valid in law. So we've got to rely on what the client says. But if the client just gets it wrong, but has taken reasonable care, then we are exposed to all those liabilities through no fault of our own. And part of the difficulty I have is explaining that this is not about what's right. This isn't about moral justice. This is about HMRC collecting tax and NICs, and they want someone to be able, to have to pay those tax and NICs. So it's the fact that it's unfair can be quite difficult for people to get their head around. But that is the way that the law is worded, and in fact is the way that the law has been worded since the public sector rules went live as well. So this is not new, it's not accidental, it's very deliberate.
Yeah, and I guess we should just focus a bit there on the status determination statement in terms of passing it down the chain. You mentioned there that at the outset, the client is considered to be the deemed employer and the fee payer at the point that they start the process. But again, assuming that they've taken reasonable care and they've reached a decision and they've passed it on to the next party in the supply chain, then it's a bit like a hot potato, isn't it? It's just it's moved from one party to the other, and whoever is holding that has got that sort of fee payer risk and essentially classed as the deemed employer. But in situations where I guess we look at when it does go wrong, and how does it work in terms of coming back up the chain? So let's say there is a situation through a process later on that the status decision was incorrect and that there is a liability. We know it starts with the fee payer, but what if that fee payer, for instance, goes bust or cannot make the payment? How does it then work in terms of flowing back up?
Yeah, so if HMRC cannot collect the liabilities due from whichever party failed to comply with their obligations, and therefore is either the fee payer or deemed to be the fee payer because they didn't do what they should have done. If that business ceases to exist for any reason, then HMRC can use separate transfer of liability provisions, which are not written into Chapter 10 ITPA. They're actually written into the PAYE regs. Then what HMRC can do is say, okay, well, we can't collect from the fee payer. So under those circumstances, what we will do is we will go to the agency closest to the client, if that is not the liable party, you know, the party initially liable. And they will be responsible for paying us all of those liabilities. Now, if that fee payer that didn't do what they should have done and ceased to exist is the company closest to the client, or indeed if they weren't, but they also cease to exist because they can't pay those liabilities, then HMRC can and, you know, could pursue the client. But, you know, again, that causes a lot of difficulties for MSPs and RPOs because, you know, they are rarely the fee payer because they are not the ones paying the PSC. They engage a second tier agency, and, you know, their obligation under the off payroll rules is simply to pass the SDS down from the client to the second tier agency. And then, of course, unbeknownst to them, all of those liabilities could then come back to them under this transfer of liability provision, which again isn't fair, but HMRC want somebody to make those payments. You know, they won't say, oh dear, this company doesn't exist anymore. We'll just stop what we're doing and close that down. I mean, Tom, what do you think?
Well, I think you're exactly right there. I mean, you know, HMRC will pursue the debt, and from what you're saying there, I think when we talked about insurance earlier, what it seems to me actually is all these insurance policies are aimed at the wrong person. What you nearly need to be insuring is the fee payer, because they're the ones that the liability is going to be on, and they're the one that it's going to be transferring down the chain. So actually, by insuring that party, you're protecting every other party in the chain.
Yeah, there's some question marks over that in terms of how that type of insurance works, where you're sort of taking an insurable interest in a third party. And I think there's certainly a number of insurance companies I've spoken to that have raised some question marks over how the insurance that is being offered to many at the moment will actually work and could work. And it will be interesting to see how that plays out.
I think you're right there, Chris, and clearly you have a background in the insurance industry, but insured party is the key word there. Who is the interested party in it? And when you look at these debt transfer provisions, you have to put that in the context of the insurance policy. And I think you're right. I think it's covering the wrong person.
Well, I guess we're going to find out in a few years' time. So when we look at this risk that we've been talking about in terms of, you know, the fee payer risk, of which the liabilities and the penalties can be quite substantial, how is this affecting commercial contracts? I mean, is it the case that, you know, fee payers can mitigate their risk through their commercial contracts? Are they just getting situations where you know, the big client is saying, no, we're not prepared to accept that risk. It's up to you. If you want the gig, then, you know, you just have to accept the risk.
You know, on top of all of the sort of running around that everyone has to do to get ready for the legislation, there's a sort of a secondary requirement of running around in terms of the contractual arrangements that then, you know, govern the situation going forward. And you know, as always, you know, is the case, there is an imbalance of bargaining power between agencies and their clients. So, you know, accepting anything that the client passes their way in terms of contracts and either not reviewing them robustly enough or accepting those kind of risks. So what we are seeing is a lot of clients now, instead of signing agencies' own standard terms and conditions, we are seeing a lot more clients now issuing their own terms and conditions for agencies. And in those terms and conditions, they, you know, include a clear tax indemnity. And that indemnity is usually worded to such a wide extent that the agency would be liable for all of the off-payroll liabilities, even where the client has not complied with its obligations. So it doesn't require the fault of the fee payer for the indemnity to take effect. It just says if there are any liabilities that the client incurs in relation to the off-payroll rules, the fee payer will indemnify them. And that gives clients a massive get out, because it means they can use poor tools or no tools at all, or do blanket determinations, knowing that they are indemnified by the agency. Now, of course, that is unfair. Again, it's not good practice, and there will be lots of good agencies that will refuse to take that position. But also, of course, just because a client has an indemnity in its terms and conditions, that doesn't mean that they can sit back, put their feet on the table and drink cups of tea. Because if those liabilities are sufficiently large, then of course that company, that agency that signed the indemnity will and can and will cease to exist. They will simply dissolve the company to avoid that indemnity. And of course, an indemnity is only worth the assets of the company sitting behind it. And if no company exists anymore, then the indemnity is worthless.
Bernie, sorry to interrupt you, but when we say sufficiently large there, I mean, you're only talking someone working in a non-compliant way for a couple of years, aren't we? When we see a liability that can build up to 1 million plus very easily.
Yeah, so I've done some, sadly, I've done some quick calculations actually. And if you have a contractor who's working on £60 an hour, which is, is a lot, but it's not enormous. They work for 12 months, only working days, but there is no absence, no holidays or whatever in the meantime. So 12 months. Then in one tax year alone, the liability just for the income tax and the NICs is £60,000, over £60,000. Now, if you have 20 contractors in that same position, the liability in one tax year alone exceeds £1 million. So you're absolutely right. Those liabilities rack up so fast.
So I mean, this is the danger, isn't it, of, like you say, putting your feet up and thinking that, well, I'm indemnified, because actually that indemnity is going to be worth nothing if all of a sudden 3 million liabilities causes the indemnified party to fold, and you're left holding the liability.
Yeah, absolutely right. Absolutely right. And and just going back to the issue of insurances, certainly no insurer will insure the agency against a contractual indemnity of which they have no control. Insurances generally do not cover indemnities in commercial contracts. So the agency will be uninsured, regardless of if they have some other kind of IR35 insurance. If the client hasn't done what they needed to do, that insurance won't kick in. And if the agency has indemnified the client in a commercial contract that is irrelevant to the off-payroll rules as they are worded, that IR35 insurance will not cover that.
I mean, this just goes back to this, concept of, well, I've got a status determination and therefore I can rely on that for the next 12 months. I mean, this just emphasised for me the importance of those in-flight checks as you're working in that contract. Those need to be monitored very closely, and 3-month and 6-month touch points. Let's have a review. Is the working practices still reflecting that status determination? And that is going to be so key for fee payers.
Yeah.
Yeah, and have you also seen situations, certainly as I've heard reported, where the fee payer, in order to try and mitigate the risk that's sort of being passed down to itself through the contracts from the end client, then looks to offload their liability and risks onto the PSC, onto the contractor itself? Are you seeing examples of that?
Yeah, I mean, to be honest, most agencies do flow a lot of their liabilities and obligations, whether statutory or contractual, down to PSCs. It's quite common practice to what we call back-to-back, the client contracts and the PSC contracts. So the agency signs up to certain things with the client contract, but then flows all of those liabilities down to the PSC. And although it's common practice, and certainly. I would have taken that approach as well when I was, in-house in an agency looking after their legal and compliance. The fact is that it's just paper, because particularly individual PSCs dissolve at the drop of a hat, literally overnight. So, indemnities are all very well and good, but particularly flowing down indemnities to PSCs is highly, highly risky. And on the very few occasions when in my previous experience working in agencies, on the very few occasions that we have tried to rely on the indemnity, the contractor has simply dissolved the PSC, to avoid those indemnities and liabilities. And quite frankly, I don't blame them. So, again, agencies who are trying to offload, they are at even more risk of that indemnity becoming worthless. So, it's that is not the way to manage your risk. As Tom was saying, for agencies, the way to manage your risk is to ensure, as far as you possibly can, that the client is using the right way to determine status, that it is accurate, it is consistent, and that they and the client are working together to make sure that that status determination remains correct, regardless of, and any changes in the assignment over time are monitored and, reassessed if needs be. That is, it's through practice, not through contracts, that you will mitigate your risk.
This is prevention being better than cure, isn't it? I mean, this just it illustrates very, very descriptively that not getting the right processes in at the beginning is going to cause problems as quickly as 18 months down the line.
Yeah, couldn't agree more. So I guess one of the final questions are just to sort of bring up here, and again that gets raised quite often, is the risk to the contractor themselves, where they're very fearful of the situation that presents itself coming this April, in the sense that they're currently working through their limited company. They've deemed themselves to be outside of IR35, and now, essentially under the same working environment and end client, they find themselves on the end of a determination that says that they're inside IR35. Much has been said about this risk, and HMRC have been very clear to point out on a number of occasions that they're not looking to go backwards, but can we really trust this situation, and can contractors be confident that they can move forwards, or is there a genuine risk there? I mean, Tom, you must have a fair bit to say about that.
I think there's many people that would balk at the idea of trusting HMRC at this moment, Chris, and probably for many good reasons. Listen, I think we know what they've said. They're not going to use this as an opportunity to revisit the past. However, that is caveated with where there's evidence of deliberate misrepresentation of status, or I will say even evasion and fraud, then all bets are off. So if you have been working, and I think it's fair to say there's a large part of the population that has not really paid particular attention to their IR35 status over a number of years, instead assuming that they are outside IR35 rather than making any proper determination. What is deliberate? I mean, that is deliberate to me. That is a deliberate effort not to, well, it's certainly not. Yeah, when it comes to behaviours in tax, there's three behaviours essentially. There's mistake despite taking reasonable care. There's carelessness, mistake despite taking reasonable care, carelessness, and deliberate. Now you can't say it's a mistake. You can't say there's been reasonable care there, so you're left with deliberate. So actually, I think whilst a number of people are taking that as a comfort blanket, I think that definition of deliberate is sufficiently wide that HMRC would see that as an opening for going back through earlier years. I don't know if you've got any thoughts about that, Bernie.
Yeah, only that I think, looking at it from a purely practical point of view, we know that HMRC is under-resourced, and therefore they're more likely to get bigger bang for their buck by enforcing the Chapter 10 rules, the off-payroll rules as they are now, rather than, focusing their time and energy on historic investigations under Chapter 8, which is what the IR35 rules are now for the private sector. But having said that, you know, if everyone's doing what they should be doing and doing it well under the off-payroll rules, well, in a couple of years' time, in theory, HMRC might start to think, well, what do we need to do now? I mean, the whole point of the off-payroll rules is essentially for companies to self-comply. That is HMRC's aim, right? They don't want to have to investigate anyone. They just want to sit back and watch the tax roll in. And if they're not getting where they want to or need to with their own enforcement, or indeed under the off-payroll rules, all companies are taking a really good approach and, you know, making changes to working practices and contracts, you know, continually over time to try to ensure as many are genuinely outside IR35 as is reasonably possible, then they may not get the gains that they think they make. Certainly they won't make the gains that they've told Parliament they'll make. So, you know, then there is absolutely, as Tom said, there's a real threat there that HMRC will say, we're not getting all of the money that we thought we would. So what other options do we have? And they are very vague in their wording, as Tom has made clear, about when they might open a historic investigation. And a lack of contractors doing their own assessments to any degree, arguably that's a deliberate act, or rather deliberate omission, and therefore surely, you know, that isn't compliant, and therefore that opens the door for HMRC.
What we do know is that going forward after the reforms is that they will be focusing for 12 months very much on ensuring the changes, the reforms have bedded in. What I mean by that is we know that they are going to focus heavily on areas that they know PSCs are used. So you're going to see nudge letters. You're going to be seeing letters saying pre-reforms you had a number of contractors. After the reforms, you still have a number of contractors. Have you been doing your due diligence, and have you been doing your determinations? Now, clearly, as Bernie says, resource is always an issue at HMRC. A letter may be enough for some people. They may say, we've had a reply, we've had a response, we accept that argument. But for many others, they will want to see some evidence that those procedures have been put in place. They will want to see determinations. Now, what they've said is penalties will not be charged for the first 12 months. But as we've already established here, penalties are not the risk here. Penalties in terms of the tax at stake are very small. You know, it's going to be the tax that you potentially are liable for that's going to be the issue. And that is going to start from day one. There's going to be no amnesty about that.
Yeah. I guess finally, just looking at that, and again thinking about the decision that's found its way down to the contractor, in situations where they have been given an inside IR35 determination, having, again, as I say, previously declared themselves to be outside, what are the steps that they can really take to sort of challenge that? I mean, let's say they really were firmly of the belief that they were operating outside IR35, and it wasn't, you know, in any sense a contrived situation, and here they are, they've received a determination down through the supply chain that says that they're inside. I mean, what are their routes out of this? Can they, we know that there is a client disagreement process, but what exactly does that process take?
Well, there is a statutory requirement for clients to implement a status challenge or status disagreement process, which can be utilised either by the affected worker or the fee-paying agency, but nobody else, interestingly. So they can challenge the client, and there is no set way that the legislation states that they must do that, but presumably it would at least have to be in writing. And clients may choose to implement quite a difficult way for people to raise challenges if they were so minded. But, you know, once a status challenge has been received by the client, they have 45 days to respond. But of course, in the meantime, while this 45 days is going on, you know, the fee-paying agency, if there is one, has to follow the client's original determination in the meantime. So, you're talking 4, potentially even 6 payments to contractors in the meantime if they are weekly paid. So, there are, the original determination is what has to be used in that meantime. So 45 days is quite a long time to respond, but it is what it is. And then, of course, if the client says, well, we believe our original status determination statement was correct, then they need to state that and give their reasons as to why. In the very unlikely situation that the client decides they were wrong, then what they have to do is they have to issue a new SDS, of course, having taken reasonable care, and explain their reasons as part of that new SDS, and formally withdraw the old SDS and state the date that the new SDS takes effect, which of course could be from the beginning of the assignment, but could be from the date that the new SDS is actually issued. And then what you do about whatever tax and NICs has been paid in the meantime, that's all, there's not a lot of guidance. Tax and NICs, if the client changes his mind and it be and changes from an inside to an outside determination, the tax and employees NICs, arguably you can get back via RTI, because that's where, the payroll, the way in which you pay contractors if they retain their PSC and work inside IR35. But most of them won't, of course. Most of them will move instead to agency PAYE or umbrella, and then they will go back to their PSC, meaning they are no longer on RTI for the purposes of getting those tax and NICs back. And there's no way to reclaim the employer's NICs or the apprenticeship levy. So what that sort of midpoint, how that happens, we don't have any guidance on. I think people just accept that it's been paid and they can't get it back. But interestingly, the problem with the run up to go live is, of course, clients are issuing SDSs now because they have to, because changes to assignments may need to be made, changes to payroll mechanisms, changes to contracts, etc. So clients are issuing their SDSs now, and if it's inside IR35, PSCs and fee payers will want to challenge that. But at this point in time, there is no obligation on the client to have their status disagreement process in place, because that legislative obligation only takes effect from the 6th of April. So fee payers and workers can issue challenges now. The client can completely ignore them, and they have until 45 days after the 6th of April in which to respond. So for this interim period, this transition period from old rules to new rules, there is absolutely no avenue for contractors to challenge the decision. The only thing they can do is challenge with their feet and walk, leave the assignment.
Yeah, crikey, what a mess. We've got some interesting times ahead. Thank you very much for that. I don't think we have anything else on our sort of agenda to talk through, unless there's anything that anyone else wants to sort of float up. I think we've covered quite a broad range of topics here. Right, very good. That's good, everyone. Thanks very much.